So, good afternoon, guys. My name is Alina Shaltsova. I'm a New York immigration attorney. Today we are having our live. We're going to be talking about visa bulletin. That line that you have to stay in prior to submitting for your immigrant visa or prior to submitting for that adjustment of status if you're in the United States. We have some good news about advancing about certain categories that got advanced for this October 2025 visa bulletin. And in the end, if you guys like, please ask me questions, type up hellos, let me know where you're watching from, and we're going to start. So first of all, I wanted to share with you good news and let you know that in October of 2025, for both employment cases and family cases, the Department of State determined that dates for filing can be used. Typically, those dates for filing are much more advanced than dates for final elections, and it means that you can start working on your case faster, right? It also means that you will be able to perhaps maintain that bridge, that legal status easier, because you will be able to file for adjustment of status faster if your date to file for adjustment of status is sooner. So let's talk about this. F2A category, preference category for spouses and children of permanent residents, is a very popular category. For October 2025, jumped to September, dates for filing, jumped to September 22nd, 2025. To compare, this month, only people who filed their cases prior to January or on January 1st to June 1st, 2025, were able to submit their adjustment of status applications. It means that in September, there was about 3 months gap between you be able to file I-130 form and file I-45 form. But in October, starting October 1st, you only have to wait for 8 days. In other words, if you're going to submit your application, I-130, or your spouse is going to submit your application, I-130 now, in October you'll be able to file for adjustment of status. So I think it's a very good news. Right? In F4 category, very popular category for siblings of US citizens, we have a little advancement as well, not as noticeable, not as profound, but it's an advancement by 2 months. Well, guess what? Sometimes it's only 1 month's jump, so it's good news still. But another good advancement we see in employment cases. Remember that according to this visa bulletin announcement, you will be able to file your case using chart, your employment-based case, using chart for dates for filing, right? And for October, for example, in EB2 category, EB2 perm or EB2 national interest waiver, if you've submitted your I-140 on prior to July 15th, 2024, which is only August, September, so it's a year and 2 months, right? Ago, you will be able to submit your visa application, or you will be able to submit for your adjustment of status. September has November 15th, 2023 date. So in September, the gap is much broader. Almost, a little bit more advancement we see also in EB3 category, but not by much, only by a couple of months. So for employment category in EB3, for EB3 cases, you will be able to file your case if you started your I-140 petition was filed uh, prior or on July 1st, 2023. And in September, it was May 1st, 2023. So two main fields that got the most benefit, got the most advancement are F2A and EB2. Well, guess what? Those are very popular fields. Some of you are anxiously waiting to be able to file for adjustment of status because you are in the United States, right? Your status may be expiring or you're not sure what's going to happen with your status. And I think it's a very good news. Now, you need to know another very interesting thing. Despite the long-term policy that you have to maintain your lawful status up until the point when you file for adjustment of status. Recently, we've seen NTAs, notices to appear, issued to people who, guess what, maintained their lawful status up until the point they filed for adjustment of status, but then they stopped. They stopped going to school or they did not file for extension of their B1, B2 status. Such people were issued NTAs. It means that they will have to finish their adjustment of status process of receiving a green card in court, most likely. Well, we are filing motions to terminate such proceedings, but the government is fighting them. All right, I have no idea why, because I feel like it's a waste of everybody's resources, but that's what's happening. So just keep that in mind. All right, I think overall, this Bulletin is not bad news. And now, if you guys have questions, immigration questions, I'll be very happy to answer them. Again, my name is Alina Shaltsova. I'm a practicing immigration lawyer for over, I think, at this point, 17 years in the United States. And I host these live sessions to help you guys out with your immigration questions. So please like, share the stream, send me your hearts if you're watching me on TikTok, stars if you're watching me on Facebook, and like and share the show on YouTube. And don't forget to let me know where you're watching from. And please ask your questions. Ask your questions. I can answer almost every question. Sometimes I cannot if I need to see documents. I can only speculate as to what's happening. But generally speaking, I love answering your questions and at least pointing you guys out in the right direction. Okay. Hi, Judy. Hi, Mike. Hi, Azam. Hi, Los Cali. How are you guys doing? Let me know what immigration questions you have. Let's see. Thank you very much for your gifts, guys. Thank you, user 818. Lawful permanent resident. I filed both I-130 and I-45 on March 8, 2023. I-130 approved. Should expect I-45 to be approved. Well, whether it's going to be approved, I do not know. I hope it will be. It depends on your admissibility, right? If you are admissible or not. And if you don't have any issues, with affidavit of support. Let's see. So in October, your category should be current, right? You said the March 8th, 2023, both I-130 and I-45. The only thing is this, I'm not sure in which category you were, like what preference category you were. All right, so we need to look at the visibility and see if it's current or not. Because lawful permanent resident, I filed I-130. So if it's your spouse, lawful permanent resident, who filed for you, it may be that it was your parent and you are unmarried. So I'm not sure. But if, according to the visibility, you are ready for your case to be decided, it may be decided. It doesn't have to be, I have to tell you. The interesting part about a USCIS is that just because something is current, it doesn't mean it will be decided. Hopefully it will be, okay? I have temporary 551, high name, pending, I-751. Can I travel? Yes, you can travel. However, you need to know that if, for whatever wild reason, your I-751 is denied while you're traveling, you will face issues at the border, detention and removal proceedings. So just know that, okay? Just know that. Hopefully it will not happen to you, all right? But there is a little risk in traveling while you have a pending status right now. You need to know that. So let's see, guys, from Facebook if you have any questions. Thank you for your kind words. Thank you, guys, for sharing the stream and being so kind. Let's see. I'm well, thank you. Yes. Hi, Alina. We're sharing a name almost. My husband is pending adjustment of status for marriage. Our interview happened early July, 70 days ago in Milwaukee. None of the forms 730 I-45 show any update at all. Is it normal? Yes, I wouldn't worry about this at all. Did the officer poke at any specific areas, any specific issues were raised? If not, I wouldn't worry about anything. Honestly, if you guys have a real marriage and your spouse can adjust, sometimes officers may take up to 6 months, guys, to make a decision. And sometimes it has nothing to do with you or your case. It's just the officer may be reassigned to a different position. They may file for the background check and it takes forever. It may have absolutely unrelated to your personal any issues, right? But I wouldn't panic at this point, all right? Sometimes, though, if you guys did poorly during your first interview, what may happen is that you will be called for the second interview, right? Hi, Amy Taylor. Is interview mandatory while filing for removal of condition? I had first interview already. Is it mandatory? No. But current administration loves calling everybody up for an interview. Okay? During Biden's administration, we saw I-751s being approved without an interview, but this is history. Now you can expect to be called for the interview, right? Hi, Lena Soul. How long can a person with a green card stay outside of the United States? No more than 6 months at a time. If you are planning, if you know that you will be staying longer, if there is a chance you may be staying longer, just file for that re-entry permit. It will save you so much trouble. You file for the re-entry permit, you comply with fingerprints while you are still in the United States, and then you can depart and you can go by your business. Re-entry permit is going to be mailed usually to your address, and someone, hopefully you have someone from here who can ship it to you to your home country. And at that point, even if you are staying out of the United States longer than 6 months, you will be allowed to enter back. All right? Thank you, Lena, for your gift. Hi, Jasmine Flower Girl. My son is joining the army, American citizen. I overstayed my visa. Can I apply for anything? Your son has to be 21 to sponsor you, okay? Provided that you never had any criminal issues, immigration deportation issues. As soon as your child turns 21, you will be able to file for adjustment of status. That's what it is, okay? That's what it is. And congratulations. Is asylum green card apply for home country passport? Okay, Mr. Singh, I guess the question is, if you have an asylum-based green card, can you file for the passport of your home country? Absolutely not. Do not do that. Okay? When you received asylum, when you filed for asylum, you basically stated that under no circumstances you're going to be using protections of that country, your home country, and you requested asylum. So do not do that. Okay? I understand that sometimes there are exceptions to this general advice. Sometimes you have no choice for whatever reason. So call an attorney, discuss it with an attorney. What reasons they may be, literally life or death situations, some emergencies. You must travel, but expect the government of the United States to question your grounds for asylum. Okay? As I said, sometimes we have exceptions, and it happens that they will close their eyes on this, they will forgive you. It's not an automatic revocation of your status, but you have to be very careful. Okay? If we just, not pressing, there are no any pressing issues, then don't do that, right? Hi, Lena. The USCIS officer pushed on the question on whether he was previously married. I learned later that my husband lied on his DS 160 after being married to another. He said that to get a visa. Okay, I see this. Alina, in this situation, that's your answer. Why the officer is not making a decision? They're trying to see what they're going to do with you guys. They have two options. I-130 is denied because your husband cannot prove that he divorced that person that he stated he was married to, and that's the worst case scenario. Then he will not be able to adjust status based on your petition for him. Option number two, I-130 is approved and your husband is charged with fraud, right? Lying on that DS-160 form, but usually in this situation, a waiver is available, which is a very good news. I know it doesn't sound like anything good, but it is, because if the waiver is granted, the husband is going to get a green card. In the second case scenario, you guys are going to have a chance of keeping your family in the United States. Work with a lawyer as soon as you can who can guide you on that waiver process. Okay. Hi, Musa. I have received my asylum decision yesterday and I have a master hearing on November 13th. Is there a risk to be detained? Under the current state of events, a person may be detained if they initially entered the United States without inspection. Why? Because under the current state of events, they're subject to mandatory detention under the matter of Hartudo, if I'm not mistaken, from the Board of Immigration Appeals. Okay? In virtually all other cases, even if you're detained, you'll be able to ask for bond, unless, of course, there is a certain criminal situation going on. All right? So work with a lawyer. By the way, lots of courts allow you to appeal for the first hearing, especially when you have a lawyer virtually. So see what's happening. Is it in person appearance or virtual? Is it possible to convert it into virtual? Is it possible? We have a lot of cases where we file our notice of appearance and the judge cancels, and we file the pleadings, and the judge cancels that master hearing for you at all and gives you the new date in 2028. So you don't have to go anywhere. Okay. But that depends on the judge. Nobody can guarantee you that that's exactly what's going to happen. All right. All right. Let's see. Hi, Ice. Hi, Alina. Please, can visa overstay and working without authorization before becoming an asylee after your green card application? Can visa overstay and working without authorization before becoming an asylee after your green card application? Can visa? I'm not sure, Ice, what the question is. If you rephrase it, hopefully I'll be able to answer it, okay? Just rephrase it for me, all right? Hi, Amer. Is it safe to travel outside of the United States and return back with a refugee travel document? My green card is pending. I'm from one of the travel banned countries. You should be safe. You should be exempt. But currently, I cannot guarantee you that what's supposed to happen is going to happen. Okay? When your green card is pending, especially because what if your green card application is denied while you are traveling, denied for the reason that you missed your appointment and didn't show up? Then you're going to have trouble, even though all previous administrations would allow you to enter the United States. During these times, you may be stuck at the border. So if I were you, I wouldn't risk it, I'll be honest. Typically, and always has been the case that it was safe. But now, I don't know. I'm just honest with you. Hi, Miss Selena. The person go visit his original country after becoming a US citizen, asylum. What question might face when he comes back to American airport? Usually nothing. Once you become a US citizen, US citizens are typically not questioned about anything when they're coming back home. All right? No, if you did everything the right way, you visited your country as the US citizen, you have no issues. You shouldn't have any issues. Okay. All right. Thank you, Brighton 31, for your gift. Thank you, Amaral. Let me see your questions. Hi, Chen Z. I have a notice to appear next year. Can we do this first hearing virtually? Maybe it depends on your judge. All right. And depends if you have representation. Many judges, if you have a lawyer and the lawyer files the initial paperwork in advance before your hearing date, will allow you not to appear. They will waive your appearance, and they will simply issue. They will simply issue to you the scheduling order. Okay. Right. Let's see if we have more questions. Okay. Hi, Io. In case I do volunteer deportation, is there any waiver I can file first before I leave so I can come back? I overstayed and have 10-year bar. So if you would like to file for voluntary departure, what's going to happen is that you're not going to have an order of removal against you that would require you to file for yet another waiver. But there is only one waiver that will preemptively waive unlawful presence bar. That's I-601A waiver. Okay, but to file for it, your case must be first administratively closed. That's how it works. So I don't think preemptively in your situation, if you have active removal proceedings, you'll be able to reach this goal. All right, but in terms of not picking up another bar for your return, yes, voluntarily departure is going to help you. So speak with a lawyer, see what your options may be, the prospects of you getting that immigrant visa in the future, and if that's what you want to do, okay, to ask for voluntarily departure. So, guys, if you would like to have a consultation with me, my phone number you can find if you're watching on YouTube at the bottom of the video. It's 917-885-2261, or you can visit my website, shoutsova.com, and book your appointment there. Okay. Hi, Frank Emmanuel. Hi, Lena. Any updates with ICE checking for those whose asylum was dismissed by USCIS with a letter informing them to go and request a credible fear with ICE? Yeah, sure. Those people get detained for the most part. You need to know about that, unfortunately. Okay. That's just the truth. Let's see. That's just the truth. Some people choose not to show up at all. Some people get detained and some people are not. I truly cannot guess how it's going to turn out, but you need to know that there is a great risk of detention. Hi, Lena. What happened? Hold on. I just got, my approval notice for asylum and about to file for green card. I've never had any vaccines in my entire life and never got sick. Are waivers for vaccines easy to get? No, they're not easy to get. If you didn't get your vaccines because they were not available, you will not qualify for the waiver. If, however, you are a religious person, right, and you never had any vaccines for religious reasons, then the waiver may be granted, right? That's how it is. That's how it is. All right, my question is, can visa overstay and working without authorization for about 4 years affect you when you apply for a green card as an asylee? No, no. What happens is that visa overstay is automatically forgiven to you. Work without authorization, well, there is a provision in law saying that after you file for your asylum, you shouldn't be working without authorization, okay? But I've never seen this provision to apply to any of the green card applicants. Never seen this to apply. So typically, it has never been an issue, all right? There's never been an issue, but visa overstay is automatically forgiven. Asylum case pending with USCIS. I-45. Have you ever applied for relief from deportation exclusion? Yes or no? Asylum case pending with USCIS. I-45. Have you ever applied for relief from deportation? If you've, Johnny, if this is your question, right? So I guess you're filing for form I-45 and there is this question because you also have asylum pending. This is how it goes. If you've never been in removal proceedings, you never filed for any relief. All right, so the question probably going to be no, but please contact your lawyer and ask them for a little help. These are important questions. You do not want to rely on my advice without knowing your situation, right? Because I haven't seen your documents, I haven't talked to you, and I do not know exactly what happened in your case. But typically speaking, that particular question refers to something that you filed for when you were in removal proceedings. Okay? So work with a lawyer. At least you're going to have somebody to blame for mistakes. Oh, I had a heartbreaking story. It's a story time, guys. A person came for consultation and they told me they lost their asylum case. And when I looked at it, I'm not surprised that they lost the case. They didn't have an attorney and they presented their case in a way that the judge, and it was a good judge too, wouldn't be able to grant it even if he wanted to. There was nothing there to work with. And when you represent yourself, you don't have anybody to blame for mistakes. So the point of the story was there is nothing to appeal. A person wants to file for an appeal, but there is nothing to appeal because none of the issues that would give you grounds for an appeal were raised. In this situation, it's a very tough situation because the Board of Immigration Appeals, if they see that there is nothing to appeal, you cannot voice any plausible theory, anything, then they can dismiss your notice of appeal and won't allow you to stall your deportation or removal. It's very important to understand that. Okay. All right. Okay, let's see. See if you guys have more questions. Guys from TikTok. Hi Lola, if you forgot to tell on green card interview that you've been refused entry to other country, is it too bad? I don't think they care about other countries at all, right? So if you were refused entry to Australia, why would they care? Only if the officer asks you this question for whatever wild reason, all right? And you lied to them, that doesn't look good. But if you were never refused entry to the United States, nobody really cares about that. Okay. Hi, Miss Selena. I applied for Wi-Fi 730. They got approval, but I wait for the interview. How long does it take? It usually doesn't take that long. Within most applicants, within a year, will be able to enter the United States. Okay. Good evening. Any updates after new bulletin from USCIS published? Yes, we just discussed them at the beginning of the video. So please watch it in recording on YouTube, and you'll be able to get your answers. Hopefully, right? Hi, Anjima. Do the 5-year EAD for asylum still apply and 180 days? Indeed. The government still is issuing 5-year work permits for asylum seekers. I think this is a very good news. Yes, you have to wait 180 days. However, the work permits became paid for. They're no longer free. You have to submit a filing fee. If I'm not mistaken, it's $550 for the first one. Okay? $550 for the first one. I'm pretty sure of it. And you know what's interesting? That it costs more to extend it. Yep, it costs money to extend it even more. But for 5 years, I think it's worth it. It is totally worth it. I know that some people have trouble getting real ID without the work permits and everything, so that's very good. All right, let's see if we have more questions here. All right, guys, for the USCIS fees, I don't remember all of them by heart. I'm not a computer. There is a USCIS tool called USCIS filing fee calculator. You Google it and you check the filing fees. All right. All right. Let's see. Nish, do you have to show tax paperwork and citizenship application even if you don't earn anything? Nish, you have to file taxes. All right. Most people must file taxes. If you don't file taxes, they're going to ask you what resources, what money are you living off, right? So if you work, if you get income, you have to file taxes. But what happens if you legitimately do not have income? Well, things happen for a variety of reasons, and somebody else is supporting you. Then you will have to usually produce an affidavit saying, I didn't have any income to report. Okay? But you need to know, and I have a video about this, that USCIS adjusted the rules as they relate to naturalization application. They are going to check if you've been paying taxes, filing taxes, paying taxes, and if you owe anything. And here is the situation. They may think that if you did not file any taxes, you may owe taxes, and your naturalization application may not be approved. So prepare very well to explain why you did not have to file taxes, okay? Hi Malik, for almost 4 months after the interview, no decision. It depends what interview you had. Asylum interview, USCIS interview, based on marriage, whatever happened, right? And I'm not really surprised. I don't think it's too long to wait for, especially if it was an asylum interview. What happens with those interviews? We are seeing great delays, especially now when asylum officers all of a sudden interviewed in bulk cases that were filed in 15, 16, and 17. They're not ready to make those decisions. And initially, they would tell you, come and pick up your decision within 2 weeks after the interview, but then they're going to tell you not to come and they will mail you. Some people are called for a second interview. So, not sure what's happening in your case, what type of a case it is, but you have to wait for the next step, another interview or decision, right? All right. How long does it take to get a green card after applying? I guess, guys, it depends on your case, right? Depends on eligibility to some extent, on the priority date, if it's going to roll back or not. And on your case, usually within a year, you will be able to get your answer. All right, usually within a year. All right, let's see. Hi Lola, if they ask denied of entry and he forgot because it was a long time ago, if they ask if he was denied entry into the United States and he forgot, I don't know. It may be a problem. It depends on the circumstances. Okay, it depends on the circumstances. Thank you guys very much for your gifts and for sharing the stream. Let's see. All right. Let's see the questions. Hi, Najima, is it true applying for asylum now and you're getting deported? No, it's not true. Some cases for asylum get approved, just like always. If you guys qualify for asylum, why would they deport you instead? No, it's not the case. Hi, Search. Hello, Alina. How long is removal of conditions taking right now? We applied in March of 2024. Search, everybody's case is different. It is not for nothing that they extend your green card for 4 years, right? On average, I would say at least 2.5 years it takes. And they may call you for the interview. It all depends, I guess, what evidence you filed with your I-751 form. If you submitted birth certificates for your children, purchase of a house, there is really no reason for them not to approve your I-751. If less heavy evidence, then they will take their time. Okay. Hi, Sylvester. Can I apply I-130 for my spouse? Come from a partial ban country. I have 10 years green card. Yes, you can. You can file at I-130. All right. Let's see. What makes you inadmissible for adjustment of status? A dismissed case or conviction? Please elaborate. Inadmissibility, well, there is a whole section in Immigration Nationality Act. Criminal grounds may be grounds for inadmissibility. Sometimes even a criminal charge that was dismissed may be if you admit to the essential elements of the crime in front of a USCIS officer. But not only that, in certain situations, for example, unlawful presence time may be a problem. And certain situations, claim of a US citizenship may be a problem. So we have a lot of different grounds, believe it or not. Most of them do not apply to most people, but sometimes there are exotic situations when they will be. So to see if you are admissible or not, you should speak with a lawyer. We need to know the basis of your application for the green card. So, for example, if you are married to a US citizen, but you do not have a legal entry, you are inadmissible. You cannot get a green card. If you are married to a US citizen, you do not have a legal entry, but you're filing for VAWA based on that marriage, the fact that you don't have legal entry does not matter. All right? Same thing with criminal convictions or criminal arrests or criminal charges. Some of them present a problem, some of them do not. For some of them, you're going to have a waiver that you can file for, and sometimes you can't qualify for the waiver. So there is a long analysis that lawyers would engage in to determine whether or not you'll be able to probably get a green card. Why probably get a green card? Because in the very end, it is up to USCIS to grant it or not. Sometimes there are situations where a person's pattern of behavior would prevent them from getting a green card, because a green card is a discretionary relief, discretionary application. I've seen two cases where people were not criminally charged, did not commit any fraud. Nevertheless, the green card was denied. One situation was when the person had 47 parking tickets. Why they had 47 parking tickets? Well, they worked as a cab driver and they were often trying to solicit customers at JFK, and they picked up all these tickets, okay? For not one day, but nevertheless, when officers saw it that, they have so many tickets, they said, no green card for you. And the second situation was more problematic from my standpoint of view. It involved an applicant for a green card whose asylum application was granted. But at the time when that applicant filed for asylum, he worked with a lawyer who later was federally convicted of immigration fraud. So when the person appeared for the interview, the person was questioned about that lawyer. On advice of the counsel that the person was with, the person refused answering any questions about that attorney that the person previously had when filed for asylum. USCIS turned around and said, very well, if you are not answering our questions, we are not granting your green card application because we don't have to. Okay? And that's what happened. So be wise. If you have nothing to do with that attorney's practice or paralegal practice, or whoever you found somewhere who later turned out to be a fraud, why wouldn't you not talk about them? It doesn't make any sense. Maybe your encounter with that person was very short and very simple. You thought they were a legit lawyer, you gave them the money, your story was true, right? Unless there was something else involved. So I guess what happened in this case that the government started having serious suspicions that something else was happening. And maybe the person didn't really qualify for asylum because they did not want to talk. I do not know. Again, it's a personal situation, but work with a lawyer. But keep this in mind: green card may be not approved if USCIS has reasons to believe that you don't deserve their discretion. And there are various courts' decisions about this, depending on the jurisdiction. Some courts say they're not going to review this. Some courts say there is an abuse of discretion, so it's not that straightforward, right? Some people say, oh, we're just going to sue them and get our green card. Nuh-uh, doesn't work like that, all right? Doesn't work like that. Malik, oversee marriage-based I-45, and you're waiting for 4 months for the decision. Again, same question. Were there any issues during your interview? If they were, you may be called for the second interview. Okay. Hi, Blessing Chin. Do you recommend filing for N400 with a pending I-751 if it is taking too long? Sure. If by now you qualify for citizenship, file for it, and you will be called for a double interview, so appear with your spouse. Okay. Hi, Tumbleweed, love you. Telling real life stories. Immigration law is so complex. Thank you very much. Yes, it's also very interesting. When you work with people, I guess it's always very interesting. And when you appear for those interviews and everything, sometimes it's really get entertaining, when your clients surprise you with answers. So guys, rule number 1, do not surprise your lawyer with answers. Tell them everything from the very beginning. So when you appear for that interview, all of a sudden your lawyer doesn't have square eyes when you say that you've been married 10 times instead of 2, as you were telling them. Sometimes we can really get caught off guard. Hi, Javid. Why my N336 taking so long time in Long Island? Well, here's your answer, because it's a Long Island. It's a joke. No, I do not know. Traditionally speaking, N336s are taking a long time. Maybe it was easier for you to refile your case. All right. I do not know. Can I do something about it? Well, I can. But why do you want to do something about it? I mean, something. You know what, Javid? I'm gonna advise you. I do not know how long your N336 is pending for, but why don't you contact the congressman and do something for you for free? Contact congressman and ask them for help. They're going to follow up on your case and they're going to give you the answer. All right? Hi, Abdul. My case is being over 5 years in BIA. Anything I can do? Yes, you can. You can file a motion to expedite decision. But before, guys, you're going to try to do anything. Please hear me out. In most immigration categories, now is not the time to gamble with your decision. Unless you're absolutely sure that you're going to win that case, please don't rush it. You should follow Board of Immigration Appeals decisions. Most of them are not friendly in terms of for people who had criminal convictions, people who are seeking asylum, and things like that. So make your decisions wisely, okay? Be wise. Right now, for example, you have a Board of Immigration Appeals decision pending. Most likely, you have a work permit. If they will deny your case, what are you going to do? The only thing that you'll be able to do most likely would be rushing to file that petition for review in the federal court that costs an arm and a leg. So keep that in mind, okay? I-130 was approved and I-45 is pending after RFE was sent. Request name discrepancy. What's next? Next would be to wait for them to resolve that discrepancy. All right, what happened? Was there a mistake? Was there misrepresentation? Did you use several names? It's very important sometimes. All right, good morning, Singh, Jill. Rupinder Singh, Jill. Good morning, thank you guys. Hi, Manchester. My citizenship is near and I've done one volunteer service. How many more is appropriate? Oh, there is no real number that you have to show, like I'm volunteering every week. No, be yourself. Listen, if you're overall a decent person, right? You don't have criminal past. You have stable employment. You have community ties. You have family ties. Or maybe you are here by yourself, but you've been filing your taxes and you are not trashing anybody online. All right, you should be fine. That's my take on that. I don't think that they're going to really go after every single person so harshly. You have something to show that you volunteered. Do you have any education? I mean, it depends on your factors. You know, like I would need to speak to a person to determine what's happening. Like, do they have a business? Are they employing somebody? Are they overall law abiding citizens? Do they go to church, a place of worship, right? What's happening in their lives? And then I would make my recommendations. Let's say you had some encounters in the past. Then, of course, you have to show that you have rehabilitated prior to filing for the citizenship. So I would say it depends. I would say that if you are this boring person who minds their own business, right? Most of the times you will be fine, but attach proof of tax filings, maybe letters of recommendations from your work, maybe some letters of character from people who know you, okay? And don't argue with your neighbors. Hi, Jess 1938. Can BIA motion to reopen denied if misrepresentation in asylum case 20 years ago, now married to a US citizen, I-130 approved? Of course it can be denied. Listen, will it be denied? I do not know. It depends maybe if it was a very important issue in your case, how well you addressed it and explained it. Misrepresentation is one thing, but frivolous asylum is another. Okay? So whatever happened, I hope your lawyer covered the situation. If there was a misrepresentation, just misrepresentation, most likely you will need that misrepresentation waiver when you're filing for the green card. Just keep that in mind. All right? All right, guys, I'm going to answer one last question for tonight. Hi, Cheery. I came by friend's visa, fiancé visa. Oh my God, my eyes don't see anything. I came by fiancé visa and marriage failed. Now I'm in removal proceedings. Also, I'm asylum seeker. All right, Cherry. So what happens here is that a person who entered the United States on a K-1 visa can't adjust status. But if you win that asylum, then you're going to have a chance. All right, that's what it is. All right, guys. Pretty corny. What is your question? Somebody is begging me for a question. Come on, ask your question. All right, ask your question. I'm going to give you a couple minutes to type it up. I have an error fee for I-864 and they ask for evidence. Okay, evidence of what? But no pay stubs. Do I submit pay stubs? They ask for evidence. All right, so I-864, this is what you do. If a person is working on W-2, right? Present a letter from the employer confirming their position, the person's position, yearly salary, how much they make per year. So the officer doesn't have to calculate how much they make if you put hourly there. Yearly salary, if bonuses are going to be paid as well. Sometimes, you work and you're guaranteed a bonus. So that should be included. So that's one proof. Tax returns for the past 3 years. So the person was filing tax returns for the past 3 years. Pay stubs would be wonderful. You say that there are no pay stubs. I'm going to tell you something. Basically, do I need to submit pay stubs for joint sponsor? Yes. If they work on W-2, you should. Everybody has pay stubs. Under the law, you have to have pay stubs. It's a different story that employers sometimes don't issue them. But upon request, they're going to call their accountant or their payroll company and they will give them to you or to that person. All right? So if the person works on W-2, they should have pay stubs and it's easy to receive it. Trust me, I know it. They call their payroll company and the payroll company is going to give them those 2 pay stubs for the past 2 weeks. All right? I have the pay stubs, the most current. Just want to know if they didn't ask for it in the RFE, so should I? Yeah, of course you should. You want to prove income, right? So you want to make sure that you have this very clear evidence that the joint sponsor makes enough income, so they would leave you alone and move on to the next person they're going to be harassing about the pay stubs. Funny part is that no matter how much good, strong evidence you submit with the initial I-864, USCIS will always ask you for more proof. And even if you send them identical evidence with that RFE, they will still going to send you that RFE. They don't care. So I feel like they use this RFE just to slow down your case. All right? All right, guys. Do I still need a job letter? Yes. Yes, you do need a job letter. You want to pile up that evidence. You want to pile up the proof that your sponsor has enough income. Because what you want the green card, right? And when you want green card, you want to document your case very, very well. Most likely you have 89 days to present your evidence. Plenty of time to harass whoever you need to harass in payroll company to get those pay stubs and letters. All right, guys, thank you very much. I hope you're going to pretty corny sign up for my channel after this advice, and the rest of you guys too. We're going to see each other again, hopefully Friday night, if everything is well. I hope you're all going to have a wonderful, productive week, and I hope to see you guys all soon.